Sure.
I'm afraid you're a little got one.
Good evening, friends, and thank you for being with us tonight. Welcome to the Daniel Webster Debate Series, hosted by the Georgetown Law Federal Society. This series is dedicated to Daniel Webster, one of our nation's most revered orators and public servants. Webster relied on the strength of his ideas to advance the American people's liberty and prosperity. He is rightly remembered as the great expounder and defender of our Constitution. For tonight's resolution, we ask, is the Trump administration taking the right approach to civil rights and free speech on campus? Georgetown, fortunately, has not been the subject of any recent actions by the administration.
Well,
So there is nothing to see here. It is nevertheless an important national issue of huge importance, and we are humbled to have such incredible speakers to discuss it. As our esteemed moderator, we're deeply honored to welcome the Honorable Thomas Harden of the United States Court of Appeals of the Third Circuit. Most important among his many, many accomplishments is that Judge Hardiman is a Georgetown Law alumnus. Round of applause. He likewise teaches a first-rate course on the First, Second Amendments right here at Georgetown that I highly recommend you all take. Rising in defense of the administration, our first debater tonight, we have the Manhattan Institute's Ilya Shapiro, whose deep constitutional knowledge may only be matched by his commitment to American liberty and his trademark wit. To meet his challenge, we're thrilled to have Georgetown's own Professor David Cole. Professor Cole's outstanding leadership at the ACLU has marked him as a fierce and fearless advocate for civil liberties and as one of our nation's great legal voices. This should be a stellar debate with blockbuster speakers. We're deeply grateful to the Federal Society and to Georgetown Law for making the Daniel Webster Debate Series a reality. I now recognize Mr. Chris Corain, a future clerk for Judge Hardiman, to introduce these three stellar panelists. Please give them a very warm welcome.
Introducing our panelists tonight. So moderating, we would like to welcome the Honorable Thomas M. Hardiman, who serves as a judge in the U.S. Court of Appeals for the Third Circuit, as Brady mentioned. Prior to becoming an appellate judge, Judge Hardiman was judge on the United States District Court for the Western District of Pennsylvania. Before entering judicial service, Judge Hardiman was a partner at Reed Smith, and before that, a partner at Titus and McMahon. Judge Hardiman began his legal career as an associate in the Washington, D.C. office of Skadden Arps. He received his bachelor's degree from the University of Notre Dame and his Juris Doctor from Georgetown University Law Center, where he served as a notes and comments editor of the Georgetown Law Journal. He has taught a seminar on advanced constitutional law at Duquesne University School of Law, and here at Georgetown Law, where he teaches a week 1 course on the First and Second Amendments. Mr. Ilya Shapiro is a senior fellow and director of constitutional studies at the Manhattan Institute. Previously, he was executive director and senior lecturer at the Georgetown Center for the Constitution. Before that, a vice president at the Cato Institute and director of Cato's Robert A. Levy Center for Constitutional Studies. Mr. Shapiro has testified many times before Congress and state legislatures and has filed more than 500 amicus briefs in the Supreme Court. Earlier in his career, Mr. Shapiro was a special assistant and advisor to the multinational force in Iraq on rule of law issues and practiced at Patton Boggs and Cleary Gottlieb. Before entering private practice, he clerked for Judge E. Grady Jolly of the U.S. Court of Appeals for the Fifth Circuit. He holds an AB from Princeton University, a Master's of Science from the London School of Economics, and a Juris Doctor from the University of Chicago Law School. Lastly, Professor David D. Cole is the Honorable George J. Mitchell Professor in Law and Public Policy here at the Georgetown University Law Center. He was previously the National Legal Director of the American Civil Liberties Union, and earlier in his career, in addition to serving as a law clerk to Judge Arlen M. Adams of the U.S. Court of Appeals for the Third Circuit, Professor Cole worked as a staff attorney for the Center for Constitutional Rights. He has since argued a case for the Supreme Court, with his most recent appearance on behalf of petitioner in NRA v. Vulo, resulting in a unanimous victory in his favor. Professor Cole has received 2 honorary degrees and numerous awards for his work, including the inaugural Norman Dorson Presidential Prize from the ACLU for a lifetime commitment to civil liberties. Professor Cole received both his bachelor's and Juris Doctor from Yale University. Thank you very much, and without further ado, I'll turn it over to Judge Hardiman. Thank you.
thank you, Chris. It's really a pleasure to be back at my alma mater. I want to thank Brady and the Federal Society for all their hard work. one thing I'll say about Georgetown is I definitely would not have gotten in if I had applied today. Congratulations to all of you for being here. This Daniel Webster lecture series is just astounding, the success of it. And it seems to be just a model of reason, debate, and discussion in an era where that is not always accepted. So it really is a joy to be a part of it, and it's great to be here with these two gentlemen who are very, very up to the task of debating this proposition. Is the Trump administration taking the right approach to civil rights and free speech on the campus? One thing I'll say about Daniel Webster, I don't know much about him, but I did a little bit of digging, and I knew that he was an extraordinary orator and Supreme Court advocate. What I didn't realize was his longest debate lasted 9 days. So perhaps it's a sign of the time. We are living in a faster age. We're living in a digital age, and we will not be here for 9 days.
My cutoff time is 6 a.m. and I have a flight to catch in the morning.
So this won't be exactly like Lincoln Douglas or the Webster debate that lasted 9 days was actually a series of Senate debates between Webster, who was then senator from Massachusetts, and a gentleman I hadn't heard of named Robert Hayne from South Carolina. It occurred in 1830, and they debated all kinds of issues of the day, including nullification, which was an important issue back then. And another issue that was important back then that's much in the news right now, you might be interested to know, they debated the issue of tariffs. So the more things change, the more they stay the same. So without further ado, I'm going to get out of the way and let the experts have at it, because Mr. Shapiro is advocating for the affirmative. He's going to go first, and then Professor Cole will go second. Then we'll have some brief rebuttals and then Q&A after I ask perhaps some questions of the debaters. So Ilya, you're first.
Well, it's great to be back here. Sometimes I jokingly refer to myself as Professor Emeritus at Georgetown Law. I think of the grand total of 4 months and 6 days. I think I was suspended for all but 4 days of that. So that was an interesting experience. Although I'm kind of thrown off kilter here. Nobody's chanting and banging or protesting or anything. This is not how I'm used to doing events. But nevertheless, I'll persist. And the issue here, and I'm sure Professor Cole, who's obviously a great lawyer, is going to be able to point out here and there certain things that the administration is not doing appropriately. I'm not going to defend each one of 172 different actions or however much there might be. But the overall point is that we have Title VI, which guarantees at base equal access to educational opportunity. And concomitant with that, as well as certain other contracts, grant contracts and otherwise that schools have committed to get federal funds, they agree to enforce lots of different things, ranging from accounting standards to civil rights, to anti-discrimination laws and other things. And schools have failed in enforcing student civil rights and enforcing student speech rights. We don't need new legislation to make it clear that schools are violating their duties in a whole host of ways, from not acting against encampments and disruptors, blocking access to parts of campus at UCLA and other places, the morass at Columbia, just the repeated refusal to enforce rules, takeovers of buildings and presidential offices and different standards for speech depending on the perspective it comes from. The list goes on and on. I think we all recognize that there is a crisis in higher education, one that was thrust into the national discourse after October 7th. It's not surprising that anti-Semitism is kind of the the issue that thrust all these assorted other underlying pathologies into public discourse. It often is, as Bill Ackman, the billionaire Harvard donor and trustee, put it, the same day in an essay that was published the same day that Claudine Gay resigned from Harvard. Anti-Semitism is a canary in the coal mine, a warning about larger issues, which here means everything from cancel culture to ideological indoctrination, intellectual corruption to moral decay. We've seen a subversion of the core mission of universities to seek truth and knowledge, and of classical liberal values like free speech, due process, equality under the law. These are observed in the breach. Oftentimes, it's been a shift from education to activism. I only have 7 minutes here, probably only have like 2 at this point, but trust me when I say that there are lots of examples of universities not meeting their Title VI demands. And so the question is, what should be done about it? And given that we're talking about federal funding, I mean, lots of things can be done about it by state legislatures that have been cutting DEI offices, by state attorneys general investigating violations of student rights, lots of different things there. But what the federal government can do about it is investigate and withhold those federal funds on which all of these various strings are attached. And note, they're not withholding all funds. It's not just some blunt thing, all however many millions and millions that Columbia or Yale or Penn or all these different schools have been withheld. I don't know what their basis is. I haven't looked into the contracts for the NIH funds or this funds or that funds, but clearly they're doing some parsimonious distinctions based on whatever. I don't know. I haven't dug into that exactly. And it could be that they erred on the wrong side of the particular line, but there's a reason why it's a certain amount, and it's a reason why Columbia and certain other schools are now negotiating what exactly they are supposed to do. And again, from, a lot of this could be prevented if schools just enforce their own policies. As in my lived experience at Georgetown, the issue is not a failure of having good policies. Whether it's on free speech and expression, whether it's on harassment, whether it's on anti-discrimination, whether it's equal access to employment opportunity, using the exact language of Title VI. But schools refuse to enforce their own rules, and also they have the extra baggage of DEI offices, which is the largest part of the exploding bureaucracy, the largest part in that bureaucratic growth over the last decade, whose values are antithetical to the educational mission, to the Title VI mission, because by definition, it enforces radical racialism and gender theory and other critical legal studies in law schools, critical theory of various kinds that says that there's no objective truth, that things like equality under the law and free speech are tropes of white supremacy. This is not what the Trump administration is doing, what I argue in my book, Lawless, which you can all pick up and read in lots of different formats to diagnose this crisis. This is not the latest iteration of decades-long conservative complaints about liberal faculty bias. That's an issue, to be sure, and probably more of an issue now because millennial faculty tend to be more activist than, say, baby boomer faculty, even if they equally have a D after their name, or their voting record or donation record is similar. So that's an issue. The ideological bias, even after all sorts of rulings and executive orders and what have you, that's a separate issue and a separate problem to this day. But with the problem that we're facing now and why this action is so urgent and so needed is that we've had an illiberal takeover of higher education. Folks that do not agree with the basic premises of academic freedom and open inquiry and truth-seeking, because the whole enterprise, all structures, all institutions are illegitimate because of the baked-in racism and sexism and power imbalances and all the rest of it. So it needs to be burned down and rebuilt according to new privilege hierarchies or intersectional matrices or what have you. Your rights, your freedoms depend on whether you're part of a class deemed oppressor or oppressed. And that is how Title IX offices, DEI offices, HR offices have been operating at these places in plain violation of our civil rights laws. So that is, and we've let them slide for decades. And especially it's gotten acute in the last, as I said, the last decade or so, when we've seen this bureaucratic explosion and the growth in bureaucracy, while not as sexy as debating the meaning of critical theory and, you know, Chris Rufo's latest tweet thread or what have you, that is probably even more pernicious, because these bureaucratic, educratic, diversicratic apparatchiks have no compunction to do away with standards of scholarship and intellectual inquiry and academic rigor. And so that's what's led to a host of these failures. That's why when the Chancellor of Vanderbilt, Dan Diermeyer, kicks students out of his office, he gets national plaudits. It's a low bar. You know, Ben Sass turned on the sprinklers. Great, clever solution to get rid of the illegal encampments, rather than kind of hand-wringing and hemming and hawing and deciding whether to send the police in or what have you. So too few educational leaders followed the example of former late University of Chicago President Bob Zimmer, who said, I'm not going to engage in speech policing when called to punish Dorian Abbott for various apostasies to progressive orthodoxy. So anyway, it is far too late to try to do something, you know, internally and just discuss these investigations, the withholding or the pausing of federal funds to get these important federal and state civil rights laws and to protect the educational opportunity of all our students is far it's very merited. Thank you.
So I'm delighted to be here. I applaud the Federalist Society for this debate series. I think you know what this school needs and what all school needs is more debate, more talk across difference. You know, I think on that, Ilya and I agree. As Ilya knows, I also supported him in his confrontation with Georgetown. I wrote a couple pieces defending him and suggesting that Georgetown should not fire him. And then I commended the dean when he made the right decision and offered Ilya the job. So it's too bad that Ilya decided he didn't want to come, but I'm glad that Georgetown made the right decision. So on whether Trump is treating educational institutions in the right way, you know, I heard Ilya talk for a couple seconds about that, and then I heard him go into his book condemning universities. You know, and there's plenty to criticize in universities. There are, you know, universities that are captured by the left and way too progressive, and there are universities that are captured by the right and way too conservative, and then there are, you know, universities that try to have both sides. But you know what? That's actually their right. George Mason has the right to choose to have a conservative law school. Pepperdine has the right to choose to have a conservative faculty. Northeastern and CUNY Queens have the right to choose to have a progressive education. And schools like Georgetown, Harvard, et cetera, have the right to have conservatives and liberals and try to meet both sides. But it is the right of the institution, of the academic institution, to make those choices. And the fact that some of us don't like some of those choices, and particularly that the Trump administration doesn't like some of those choices, and Ilya doesn't like some of those choices, does not authorize government to use its power to interfere with the core central academic freedom decisions of a university. You know, it's interesting that conservatives were so critical for so long about intolerance, insufficient protection of free speech on campus, insufficient protection of free speech on campus. And I supported them in that view. And suddenly now they're critical of universities for insufficiently cracking down on free speech on campus. What unites that? An antipathy to universities. Not a commitment to civil rights, not a commitment to free speech, but a commitment to let's find something we can hit universities over the head with. But the core principle of academic freedom is that universities have the right to make central decisions about how they organize student life and teaching and the like, however they want to. If they want to teach DEI, they have the right to teach DEI. If they want to teach anti-DEI, they have the right to teach anti-DEI. If they want to advance originalism, they have the right to advance originalism. If they want to advance non-originalism, they have the right to advance that. And the government doesn't have the right to interfere with that. And that's what's going on right now. Now, the Trump administration says, oh no, we're not interfering with them because they're what they're saying, except DEI, which is what they're saying, right? DEI is just training people, educating people about the legacy of racism, about how it continues to affect us. Some DEI trainings are better than others, to be sure. Some are not particularly effective. Some people might be offended by DEI programs, but it's just speech. It's not discrimination. There's no conceivable way in which training people about the history of our discrimination, talking about racism, is discrimination. What Title VI prohibits is discrimination on the basis of race if you receive federal funds. It does not prohibit training in DEI in any way, shape, or form. No court in the country has held that training in DEI violates Title VI. It also does not prohibit people engaging in anti-Israel speech in a context in which there's a war between Israel and Hamas. It also doesn't prohibit anti-Hamas speech. Both are protected. Both are protected. And schools have the freedom under academic freedom to choose whether they want to tolerate that speech or whether they want to not tolerate that speech. That's their choice. If it's a private university, that's their choice. If it's a public university, it's more complicated. But we're talking about private universities: Columbia, Harvard, Penn, Princeton, Georgetown. These are the ones that have been targeted. Georgetown for its DEI training by Ed Martin. Penn for allowing a transgender athlete to swim on a swim team 3 years ago, a decision that did not exclude any single person from participating on that swim team, which was open to all, which a decision that was not challenged by any swimmer at Penn, and a decision that was 3 years ago. And Ilya says, well, the university, I'm sure Trump administration is being very, I think he said, parsimonious about how it's tying its withdrawal of funding to the particular program. Well, at Penn, they have frozen $175 million in funding to the medical school because 3 years ago, a transgender woman swam on the swim team and nobody objected. Now, several courts have held that if they had excluded the transgender woman from the swim team, that would have been discrimination under Title VI, because that would be treating her differently because of her sex. But admitting her, allowing her to swim on a swim team that has no limited slots, did not exclude anyone, did not deny equal opportunity to anybody. Columbia, the administration froze $400 million in funding, parsimonious. The only evidence we have for why they chose $400 million was some years ago, Columbia refused to pay Trump $400 million for some property he had. And he decided, that's what I'm going to penalize them with. It has nothing to do with whatever Columbia's violations were. Moreover, the administration has not identified any violations by Columbia. It has not identified a single instance in which an act of anti-Semitism occurred and the school failed to respond adequately. What Title VI prohibits is deliberate indifference by a school to anti-Semitism. If I make an anti-Semitic remark here, and I don't make it at anybody, I've engaged in free speech. It's not a remark I would make, but it's my right to do it. If I make an anti-Semitic remark to Ilya, well, now that's targeted harassment. The school has to respond to that. But I don't violate Title VI by making that statement. The school doesn't violate Title VI by, let's assume I'm a student, and I make that statement. The school only violates Title VI if it fails to respond adequately. The Trump administration has not identified a single instance in which an actual instance of anti-Semitism was not sufficiently responded to by Columbia, by Harvard, by Princeton, and yet it has frozen funds for all three schools. It has violated the rules of Title VI, and it has then imposed on schools, and particularly Columbia, requirements that directly interfere with its academic freedom. The Trump administration has decided that the dean of the Middle Eastern Studies Department has to be changed. The Trump administration, by reports, has decided that the president of the university has to be changed, and so it was changed. The Trump administration has decided that the rules governing student protest and student discipline have to be changed without any finding of any violation of Title VI. That is a direct infringement of academic freedom, and it's something we should all stand up against. And I would suspect, and I would fully expect many conservatives to be concerned by this, because it is big government treading on private enterprise. And that's not something any of us should be supporting, I think.
All right, we're gonna have 2 minutes of rebuttal, but I have to remark before that, this might be the first of dozens and dozens of debates I've ever moderated where the panelists actually kept to the time constraints. I mean, it's just really amazing. And that's another way of saying, Ilya, you only have 2 minutes. 2 minutes here, so.
I believe in the rule of law, so that's why. Look, Professor Cole wants to make this about academic freedom, and that's not what this is about. If the Trump administration were trying to tell professors what courses they can and can't teach, I'd be opposed to that. Now, I think it might be, behoove department chairs and trustees to look at things like that, but that's not the government. That's not our resolution. This is about violating student civil rights and free speech rights, and free speech is a civil right, so it all collapses into that. This is not about an insufficient crackdown on free speech. I wrote an essay that I think holds up in November of 23 for the Free Press about delineating the different buckets of what's at issue in the post-October 7th shenanigans, for lack of a better word. There's non-speech, harassment, intimidation, vandalism, trespassing, all of these, criminal mayhem, all of these things are not speech. If you urinate on a Hillel, even though you're being both artistic and political, you don't get a defense to public urination for that from the First Amendment. Then there's things that aren't covered, the not protected speech, right? In the high bar for incitement of violence under Brandenburg and certain other things. And then there's time, place, and manner restrictions. And a lot of this debate is in that third bucket because Title VI does not allow a school to just bury its head in the ground when classes are being disrupted, when students are being blocked from access to buildings and harassed and intimidated and all the rest of these things. So this got to court with the UCLA case that finally decided to drop its appeal after it was shamed into saying, no, we don't, actually we don't want to preserve the right to, not do anything about our Jewish students being blocked from being able to access campus. This is about disruption of student organizations and classes, and the intimidation, the denial of opportunities for women in sports, absolutely, another thing from the Penn example. It's simply not fair to have biological males, whether you call them women or anything else, to compete, and that's certainly a Title IX issue. And as for the right to have liberal or conservative faculty, yeah, political protections aren't civil rights, except for a few minority of jurisdictions. DC happens to be one of them. And it's not a federal crime to be hypocritical, but in a lot of faculty searches, of course, it's an open, non-secret that there are firm racial preferences in place there too. So violations all over the board. Thank you.
So the Trump administration is not telling people what they have to teach and what they can't teach, except that the Trump administration did tell Georgetown that it had to strip DEI from its curriculum, from what it teaches, or the U.S. Attorney's Office would not hire any Georgetown students or Georgetown alum. That is directly interfering with the academic freedom of a school. What Title VI requires is a carefully tailored response to specifically identified problems. And there's a reason for that. So you have to, the Department of Education has to say, here's the problem, here's why you didn't respond adequately. Then the school has to be given an opportunity to show why it responded adequately to that situation. Then it has to, the department has to go in program by program evaluation and has to tailor the remedy to the violation. It has to provide notice to a congressional committee 30 days before it withdraws funds. The Trump administration followed none of that at Columbia, followed none of that at Harvard, none of that at Princeton. It has not followed the rules. Why does that matter? Well, because like Ilya, I'm a rule of law guy. I think procedures and procedural protections are important. But more importantly, because the line between free speech and harassment is not easy to draw. When Ilya made his infamous remark about lesser Black women, many people thought that was discrimination. They thought it was demeaning to Black women. I thought it was protected speech, but people had, reasonable people had different views about that. If I say from the river to the sea, some people will say that's anti-Semitic. Other people will say no. That is about criticizing Israel's takeover of Palestinians' lands and kicking them out of those lands and making their lives miserable. And you can have reasonable people can differ about that. The reason you need to have procedures is so you can actually determine, was what a student said harassment or was it protected free speech? And Ilya was very disturbed when some people thought his speech was harassment. And so what did we do? We had a procedure. We considered the matter and we made a decision. It was protected. And we agreed to hire him. But that has not happened.
That wasn't the decision.
That has not happened on any of the campuses with the Trump administration. There has not been a single instance in which they have identified a problem, said this problem you haven't adequately responded to, and then tailored the remedy. And if Ilya thinks, reviewing $9 billion in aid, mostly research funding to Harvard, is somehow a parsimonious response to the possibility that they failed to respond adequately to a protest that was anti-Semitic to some, well, I don't know what parsimonious means. I don't know what Title VI means. And I don't know what freedom of speech means, if that's the world we live in.
Okay, so much to talk about. Before we go to audience questions, I want to ask our panelists a couple questions. So first, let's start with the public-private distinction that Professor Cole alluded to. I think most people would understand that public universities are going to be subject more to government control than private. But the matter is complicated, is it not, by virtue of the massive quantities of federal funds that private universities receive. Do you want to talk a little bit about that? And does that make much of a difference? Does the fact that most private universities aren't like Grove City or Hillsdale, where they are truly independent because they're not taking the government money, but everybody else seems to take the government money, does that sort of put them in the same boat as public universities?
I don't think so. And I would cite for this Chief Justice Rehnquist, who in Rust versus Sullivan, which was a case about whether the government can condition its grants on speech controls, he said, well, that is clearly not the case everywhere. In the context of universities, the principle of academic freedom, the special concern of the First Amendment, means that if the government is giving you money to do some research, it can't use that to control your speech outside of the funded program. So the government certainly can say, we're giving you, $20 million to study, HIV, and you have to, study HIV with that $20 million. But it can't say, and we won't give you that 20 million if you engage in, if you allow students to engage in speech we don't like, on the student mall, that is using the sort of lever of federal funding to punish speech of the recipient outside of the funded program. And that's a violation of the First Amendment. That would be a violation of the First Amendment, even if it wasn't a university. For any recipient, the Supreme Court has held, you can control the government's money, the use of the government's money. You cannot use the government's money to try to control what the recipient does outside of the funded program. All the more so in the context of universities, where there's this principle of academic freedom that actually protects even public universities from let outside politicians control of their curricular decisions, their research decisions, their regulation of student life decisions. So no, I don't think the fact that I think again the government can control how its money is spent, but it is not in any of these cases saying you misspent our money. They're saying we don't like the fact that you tolerated anti-Semitism, what we call anti-Semitism, without identifying a single instance, and therefore we're going to pull back 175 million to 400 million, 9 billion from research grants that have nothing to do with student speech at all.
Except those research grants have incorporated in them those contracts. Again, everything from accounting standards to prevent fraud and waste and what have you, to civil rights laws, to lots of other things. There's that's the way that the higher ed funds work. That's the way any federal contracting works. You start sort of incorporating by reference all of these things, all these strings that are attached. So you're absolutely right that unconstitutional conditions is an issue. Germaneness is an issue when you're trying to pause funds and things like that. And you may be right that the government here has not been crossing all of its T's and dotting its I's. I don't want to debate process errors. They're important and should be followed. You could argue that that's a negotiating tactic or what have you, but regardless, just like that funding for HIV research can be paused to investigate discrimination, racial discrimination in admissions or hiring, it can be paused for Title VI things like being aware of students being harassed or blocked from accessing your academic buildings or classes being canceled for improper reasons. We can investigate that as a civil rights issue.
Great. What about DEI? That was fascinating to listen to both of you because you're like at different altitudes here. I didn't see any connection because what I heard Mr. Shapiro say was that the DEI programs as established were essentially a Title VI violation, and I heard Professor Cole say the exact opposite. Did I hear that right?
You have to differentiate, in my view, between what goes on in the classroom, the actual teaching or research by faculty, and the bureaucratic offices, the structures and systems and trainings and programs. I think the government is on all fours in restricting the latter because I don't think that, at least I haven't yet found any programs or structures or systems by DEI offices that that are meritorious and most of them just plainly violate existing civil rights laws. I don't want to talk,
Can you explain why? Tell us why. Can you give us a case study of how one of those offices violates Title VI?
Sure. My case is certainly one of them. To not dismiss right away any complaint that's based purely on speech, as Professor Cole said, I didn't go up to him or any other faculty member or student and make my comments. If I was harassing anyone, it might have been President Biden, I suppose, but that's another jurisdictional issue. By the way, my reinstatement was on the jurisdictional technicality that I wasn't yet employed when I tweeted, not that my speech was protected. In fact, in the report that I then got from Georgetown's DEI office after the 4-month-long farcical inquisition was made clear that if I offended someone in future with my speech or writing or what we call speech as lawyers, then that would create a hostile educational environment and I'd be back in the star chamber. So, and that's understandable because of the privilege hierarchies and power imbalances that justify different treatment based on all these different things, and of course the natural political economy dynamic where bureaucrats of any kind, be they public sector, private sector, nonprofit, or otherwise, to justify and grow their authority and budgets. And so these DEI offices create rules, field or file complaints, investigate, prosecute, and then demand more money and more staff for doing so, all to advance illiberal values, not free speech, not anti-discrimination, not equal opportunity, but quite the opposite of those in the Orwellian way that those salubrious words, diversity, equity, and inclusion, have actually been transformed to mean the opposite of their dictionary definitions.
So it's interesting that you asked Ilya to identify a single instance in which DEI violated Title VI, and he failed to do so.
I said my case.
He talked about your case, but in your case, did the administration discriminate against you because you are white, because you are Jewish, based on your race, based on your national origin? No. You say they discriminated against you because of your speech. That's not a violation of Title VI. Private institutions are permitted. I think private institutions should commit to respecting free speech of all. But when the New York Times, refuses again and again and again to publish my op-eds, they have not violated Title VI, right? They have exercised.
I know the Assistant Attorney General for the Civil Division. I'll put you in touch.
Into that. Have them look into that. The Wall Street Journal, even worse. But but that's their first.
You have no chance there.
That's their first. Exactly. I actually had, the only time the Wall Street Journal ever published something was when I complained about the way the Attorney General of New York was treating the NRA, and then they published that. But that's the Wall Street Journal's right? And it's not a violation of Title VI. So what Title VI prohibits is discriminating against an individual because of his race or national origin. That's what it prohibits. It does not prohibit teaching people about race. It does not prohibit teaching people even about terms like white privilege or white supremacy or implicit bias that the right often makes fun of and that many people find offensive. That you can teach that, and teaching that just and trying to, what DEI is basically about. I think I don't think all DEI programming is great, but I think its purpose is to try to encourage an inclusive environment in which people recognize that when you bring people together from very different perspectives, we should respect those different perspectives and we should understand those different perspectives. Does it succeed in doing that? Many times, no. Is that a violation of Title VI? Absolutely not. And was Georgetown's decision to hire Ilya and not fire him a violation of Title VI? Absolutely not, under any circumstance. So, and again, I will put, there is not a single case. DEI has been around now for a decade. There's not a single case across this country that has found that any DEI program violated Title VI. If you refuse to admit someone based on race, that's a violation of Title VI. If you impose a differential, if you're white, you have to write 2 papers, and if you're black, you only have to write 1. That's a violation of Title VI. But telling people, there's this thing called implicit bias. Maybe you should understand that people come from different perspectives and respect those perspectives in order so that we can have an inclusive environment where we can talk across the aisle like we're doing here. That doesn't violate Title VI.
Okay, no, that's fine. If speech isn't part of Title VI, then my case is a bad example of that, although it was caused by the.
Can you name another one?
Georgetown, by the way, was a trailblazer.
Can you name a single DEI case that violated
a case, an adjudicated case? No, I can't do that. But that's why we have investigations. That's why it's part. But how about this? Harvard, in the Students for Fair Admission case, argued that if we give up racial preferences, then our admission of racial minorities and especially blacks and Hispanics will plummet. Well, lo and behold, after SFFA, the first year, and the percentages at Harvard and at Yale and other places are the same. So either they were lying there or they're still engaging in illegal racial preferences. That needs to be investigated.
That's not DEI. That's affirmative action. That's very different. That's exactly what I said. It does violate.
Okay, you want to have a debate about semantics? I mean,
I think this gets me into my last question before I go to the audience. As Professor Cole noted, the line, we judges know this well, the line between free speech and harassment is hard to draw. And in some cases, the line between protected speech and unprotected speech is hard to draw. So one of the things that I heard you debate about what was going on at Columbia, et cetera, was I felt like Professor Cole was defending the rights of people to express a political viewpoint on campus, which I think everyone in the room agrees is fine. I think you agree that's fine. But what I heard Mr. Shapiro saying was this goes way beyond speech. People are being threatened, they're being impeded from attending classes, et cetera, et cetera. So let's see if we can narrow the field of disagreement there so that you're not talking about different things. We all agree that threats are not protected, but speech is. So
Sure, I have a lived experience with this as well. I've been protested. People hold up signs, they turn their backs, they hand out leaflets, they table outside. There's lots of ways to protest that's perfectly protected, both by the First Amendment in the public school context or under school policies that generally parallel First Amendment. But if you disrupt, if you make it impossible to have the event like Kyle Duncan at Stanford 2 years ago, things like that, that is not protected speech. That's not counter speech. That's a heckler's veto. That's shutting it all down. Or this student here wearing a keffiyeh might as well be a swastika, protected speech, right? He's not forcing it on anyone. It's you know, it's a symbol of hatred and bigotry, but he's allowed to do that. If he was doing it as a professor in class, there might be issues there. You know, because there's coercive elements, things like that, but just among peers, it's a different circumstance. So yeah, there are nuances.
So, you know, what Title VI prohibits is discrimination. There are two kinds of instances in which speech can be discrimination, with targeted harassment or a hostile learning environment. That's it. Blocking, you know, interfering with classes, that's not discrimination, interfering with classes. You know, that may violate school rules, but it's, unless it is targeted at somebody because they are Jewish, it is not a violation of Title VI, and the government has no interest in that. The government has no interest in whether Columbia is doing an adequate job of making sure its classes go on or not when there is a war going on in which people feel very strongly on both sides. And it just so happens that one state is religiously identified and one terrorist organization is religiously identified. And so it often is hard to distinguish between impassioned criticism of a state or impassioned criticism of a terrorist organization and anti-Semitism and Islamophobia. But it's absolutely critical that we draw those distinctions, just as it was critical in your case that we draw the distinction between harassment and saying something offensive. Saying something offensive is okay. It's okay if it's anti-Muslim. It's okay if it's anti-Jewish. Only when it rises to the level of a hostile learning environment does it violate Title VI. And again, that is not a clear line, right? There are virtually no cases deciding this is what constitutes a hostile learning environment. So every school was struggling with that. Like if someone says from the river to sea once, that's not a hostile learning environment, that's offensive speech. If someone says lesser black women once, that's not a hostile learning environment, that's just offensive speech. But if 50 people say lesser black women, or if 50 people say from the river to the sea, from the river to the sea, that might create a hostile learning environment. So drawing that distinction, super hard. And it's protected speech until you get to that point. And so that's why Title VI says, give us the specific example. Don't make these broad claims about anti-Semitism and not give us a specific example, because you might be sweeping in and I'm sure they are, sweeping in all kinds of protected speech.
But building takeovers.
So building takeovers are not protected by the First Amendment, nor are they.
So to the extent and forget about the reason.
Yeah.
Forget about Ukraine or the Middle East for a minute. If a bunch of students or visitors to a campus took over a building, is the administration within its rights, as you see it, to say, look, we're not giving you any federal money until you retake your own buildings and allow the students?
No, because there's no law that requires private universities to keep students out of buildings or to keep students from, protesting too loudly or anything like that. Schools certainly have the right to and should have reasonable time, place, and manner restrictions as private institutions to ensure that, school does go forward. I'm fully supportive of all those. Columbia arrested every person who, went into Hamilton Hall. It arrested hundreds of people who were engaged in encampments, and they're the ones who've been targeted for not sufficiently responding to anti-Semitism. I mean, I just don't get it, and I don't see any evidence. That's the key, is when you're talking about an issue where it's free speech until it's discrimination, and that line is very difficult to draw. We should not have that problem dealt with by an administration that just throws out 400 million here, 175 million here, 9 billion here, without any attempt to adjudicate what actually happened, what was inadequate, and tailoring the response to that.
I mean, who do you believe, me or your lying eyes? It seems like this is the argument going here. It's a truth universally acknowledged. What's the line from Jane Eyre or Bronte or something? That Columbia has had the worst leadership in the last couple of years. That's why we now are on, the second or third successive president, not because the administration fired her, but because this latest interim one turned out to have said one thing behind closed doors and then one thing to the Trump administration. So the Board of Trustees forced her out because it put the school in an untenable situation. But there are ways of dealing with disruptions and protests that do violate, that aren't protected speech, that harm student access to educational opportunities, that are Title VI violations. And I mean, in theory, it's possible to have pro-Palestinian protests that aren't anti-Semitic. In practice, we haven't seen that. So it's an easy case to make in Columbia more than any other, which have been the most violent.
I just don't see how you can collapse that. I mean, look, you can be pro-Israel without being anti-Muslim, and you can be pro-Palestinian without being anti-Semitic. Obviously, that's the case. These are issues on which reasonable people disagree, where both sides have killed many, many innocent people, and people feel strongly about it. But it is not to equate pro-Palestinian with anti-Semitism. That's like equating saying lesser black women, you're a racist. And I would say, no, you said something that was probably a little, intemperate, that offended many people, but you were making a point about affirmative action that you've made in more temperate ways in other places, and that's your right to say that. But it's also the right of students to wear a keffiyeh. To wear a keffiyeh is not anti-Semitic. It is not hate speech. It is talking about the rights of people.
Hate speech protected. We have no. Right. You're burning straw men here.
No. I think you are, because you have not identified. You have not identified. What you've done is not defended the Trump administration for what it says it's doing. You've instead attacked universities on grounds that have nothing to do with Title VI. You have not identified a single actual violation of Title VI. You couldn't answer Judge Hardiman's question about DEI. Is
UCLA not a good example?
Is UCLA?
Not
so give me the specific instance and tell me, I'm aware of the instance in which there were pro-Palestinian protesters, there were pro-Israel protesters, and the university did not do a very good job of keeping them apart, and there was a lot of violence. That was horrific. That was terrible. It was tragic. Was it anti-Semitic?
No,
I'm
sorry. This was not a reenactment of West Side Story. No, this was the pro-Hamas folks were blocking access and asking people whether they were Jewish or Zionist to be allowed to pass through.
So that was
blocking access,
which
is why they were sued, which is why the district court ruled against UCLA, and UCLA said that they were going to appeal to maintain the right to allow blocking of access.
Yeah, if that's an accurate statement of the facts, that would be a violation of Title VI. But notably, the Trump administration did not take any funds from UCLA. It took it from Columbia, from Harvard, from Penn. No anti-Semitism issue there. And wrote a letter to Georgetown about a DEI program. So you've identified one instance. I'll give you that instance. They were sued. Fine. But again, there's no tailoring here. Instead, what you have is an administration that is seeking to neutralize the opposition from civil society. And the opposition from civil society are the institutions that the First Amendment protects, like lawyers. They've attacked lawyers in the same broad brush way, very disturbing, universities, and the press. And all of them have been attacked in broad brush ways by this administration, totally unlawfully, Why? Because they want to neutralize the opposition, and they're actually succeeding. Very few universities have spoken up, notwithstanding blatantly illegal actions, because they're afraid. Not, these law firms are settling, not because what the Trump administration is doing is not illegal. Each law firm that went to court immediately got an injunction. Paul Clement defended Wilmer Hale and got an injunction. It is absolutely illegal. They're folding because of economic concerns about their partner salaries and the like, not because what they're doing is legal. And so that type of, I think that whether you're conservative or liberal, you should be concerned about an administration that is seeking to undermine checks and balances. Checks and balances are important no matter who's in power. And what you see with the Trump administration is it is acting blatantly illegally with respect to universities, with respect to the press, with respect to lawyers, and then it is seeking to neutralize the opposition in ways that are really unconscionable.
Well, I don't know whether this is moving the goalposts, expanding the playing field, or both, but I'll just say you have about 23 hours and 47 minutes left before you break Cory Booker's new record on anti-Trump speech.
All right, well, I'd like questions from the audience, and before I call on someone, I'll just reiterate what I've been telling students at Duquesne and Georgetown for many years now, which is, if you want to be a good lawyer, pay very careful attention to the facts, because the facts matter in cases. And I think we got a good dose of that here in this spirited debate. The law says what the law says. Sometimes the law changes. Sometimes the Supreme Court gives us new precedents that we have to tweak things here and there, but never underestimate the criticality of the facts in any one given case. And I think that's especially true when you're dealing with whether something is protected speech or something crosses the line into criminality or otherwise actionable conduct. So firsthand is, yes.
So I wanted to ask about the specific instances where students who are here on student visas, because either they participated in demonstrations or they signed a petition, including a student at Georgetown, have been put into immigration removal proceedings. I guess it's kind of two-part of one, what do you think about both the legality of that, using that particular law, and also just kind of the merits of free speech in general of the Trump administration doing that pretty much on the viewpoint discrimination.
Sure, I'll go first there. I've written quite a bit about this and done some media. So, and I guess it fits within our resolution, free speech on campus. So as an immigrant myself, I'm very familiar. Again, I have a lived experience with this sort of thing. And when I got my green card, and again, when I naturalized, I had to attest that I was not a Nazi, I was not a communist, and I did not belong to any other similar such authoritarian party. Also, that I did not support terrorism. There was a whole slew of things I had to attest to. And so even as non-citizens generally have the same speech rights as citizens in the country, I say generally because there are some marginal limitations, like you can't donate to political campaigns unless you at least have a green card. There can be immigration consequences, even to speech. And if you really want to dig deeper into the Khalil case or the Georgetown student case or the Tufts, they all have their little specific things about what's action, what's speech. But even as a matter of speech, if you give a speech in the United States as a visa holder, that would make you ineligible for having gotten that visa in the first place, because you say, I'm a Nazi and I support the violent overthrow of the US government. That speech alone can make you removable. And I think that makes sense because we as a country, any country, should be able to figure out what kind of people it wants, how long they can stay, what they can do when they're here. And one of those things is we don't want to import people who want to destroy our society, subvert the peace, all of these different things. Now, you could argue about what those standards should be, but the law as written, if you're advancing or espousing terrorism, if you're causing others to do so, all of that sort of thing is covered. So if the administration can bring the goods in terms of establishing that, well, for a green card holder, you actually get a judicial hearing, which is why Khalil is having that. For a non-green card holder, just a student visa, you just get an administrative order. It has to be a valid order, but that's it. You don't get kind of a full-throated merit examination. Then yes, those visas certainly should be pulled, and we've seen the mayhem that can result if they're not, like at MIT, for example, where lots of Title VI violations were blockages, intimidation, harassment, all this, and MIT did not enforce its own rules after acknowledging that these violations took place because so many of the perpetrators were on foreign visas and they didn't want to have them subject to removal, as the Biden State Department wrote to then Senator Marco Rubio, they would indeed be.
So I spent 20 years litigating this issue, and on behalf of a group of Palestinian students who were picked up and arrested and charged with being advocates of the doctrines of world communism. This was in 1987. And the government argued, like Ilya, well, there's some of their students, they're here on tourist visas, some of them are green card holders, it doesn't matter. We can deport them if they say things we disagree with, like advocate the doctrines of world communism. And that's actually what the law said. So we challenged that law as unconstitutional, and we argued the First Amendment protects speech. It protects speech regardless of the speaker. That's why the Supreme Court said it protects corporations' speech rights. And surely if it protects corporations' speech rights, it protects people's speech rights in this country. And it doesn't say it only protects citizens' rights. And the court agreed with us and struck down that provision as unconstitutional, and Congress repealed it. And since then, the government has not deported somebody for what they have said since that time, until now. And there is a provision in the Immigration Act that says you're deportable if you endorse or espouse terrorist activity. It has never been enforced. And it's not being enforced in any of these cases. Why? Because it's unconstitutional. So instead, they're relying on a different provision, which Ilya didn't mention, which gives the Secretary of State the power to remove someone whose presence or activities in the United States he has a reasonable basis for believing pose serious potential foreign policy consequences. And the Congress, when it passed that law, said, well, this is like when you're, negotiating with Iran over a nuclear arms deal, and you have an opposition party here, and their leader is saying something that interferes with the negotiation. You should be able to get that person out of the country. The notion that college students who write an op-ed at Tufts criticizing Tufts for, not doing enough on the war in Israel and Gaza, or that a college student or a graduate student at Columbia who merely, participated in protests and led protests on a single college campus poses serious adverse foreign policy consequences for the United States. I would think we're stronger than that. I would think that our foreign policy can tolerate people in our country disagreeing with the administration. But that's what they have said. And that is a very dangerous precedent because, the next president, the next woke president might decide that Ilya saying lesser black women poses serious adverse foreign policy consequences. So get him out of here. And I'd be the first to defend you.
I think there might be non-delegation issues actually with that foreign policy justification provision, and I find it much more constitutionally problematic than the speech implying issues. I don't know why the administration has chosen to go the foreign policy route, maybe because it's less reviewable or what have you, but I think non-delegation is the way to challenge that. And again, foreigners do have First Amendment rights. They can't be fined or imprisoned or charged criminally for doing these things any more than Americans can, than citizens can. But there can be immigration consequences for things that simply don't apply in the context of a citizen.
And then you don't have free speech. If you say you have free speech to burn an American flag, which the Supreme Court has said, but if you're a foreigner, we'll deport you if you burn an American flag, then you don't have free speech to burn an American flag. So you either do or you don't have.
Nobody has a right to be in this country. Nobody has a right to a visa. or to study at a particular institution.
Yeah, and if you take that position, then we could say, we'll support you if you support the Democratic Party, because you don't have a right to be here. So we
If
can
Congress
try to-
legislated that law, I could see a number of problems there, which an American, the Republican Party would challenge that. Not the foreigner, but the Republican Party would challenge.
And I would say, and the courts have agreed with me, that every court that has addressed this has held that foreign nationals do have First Amendment rights vis-a-vis deportation, not just when they're prosecuted criminally, but vis-a-vis deportation. That's why the McCarran-Walther Act provision was struck down. That's why Congress repealed it. And that's why no administration has enforced the only provision in the INA that still penalizes speech. And that's why they're relying on this foreign policy consequence, the term that even you agree is.
Sounds like you're making an argument like McAuliffe, interesting case from over 100 years ago, where I think Holmes was on the Massachusetts Supreme Judicial Court, and he wrote something to the effect that Mr. McAuliffe had a right to say negative things about his commanding officer in the New Bedford police force. And he exercised his First Amendment right, but he didn't have a right to be a New Bedford police officer.
Right.
And what I hear you saying is,
Wait, if
you
I'm
know,
in
somebody.
if I'm in agreement with Holmes, I have to reverse my position.
Other couple other questions? Yes, sir.
Thank you all for being here and having this debate. On kind of the DEI and Title VI debate we were having earlier, with the recognition that all those terms are a little bit hard to pin down, I'm just wondering, you know, like in a circumstance where you look at a DEI program or like a DEI offices that a private institution has, and you make the argument showing that programming creates a hostile learning environment or like creates a discriminatory environment by its programming, and perhaps the remedy for that would be like requiring actually like a dismantling of either what the trainings or the teachings, like things that look like speech. Is that a fair hypothetical to draw? I recognize a lot of assumptions there, and if it is, like, which, you know, who wins, the First Amendment or that discriminatory?
Right, so there are a lot of assumptions there. We'll stipulate the necessary stipulations for it to be an interesting hypothetical, let's say. And I would say that if the DEI program is making people less comfortable with people of different races, making them, judging them harshly, maybe some of them act in ways then that arguably approach a Title VI violation if the university knows about it. Indeed, it's creating that, which I think we may well be, this is why you need these investigations, because we may well be approaching that, because there are campus climate surveys that have been done showing that students' feeling of inclusion or belonging at their educational institutions generally, and their comfort with diversity or racial minorities specifically, is inversely correlated to the size and budgets of DEI offices. So yes, I think that is a potential Title VI violation.
You know, so
If that's true.
Yeah. So, you know, I look, exposing people to ideas that they disagree with is not a Title VI violation. I mean, you guys are doing this every week, exposing yourselves to ideas that you disagree with, those of you who are in the Federalist Society, and I haven't convinced to come on my side. But that is not a violation of Title VI, and teaching people that we have a history of racism, that people still often see the world through race-colored eyes, that that growing up Black and growing up white and growing up Hispanic and growing up gay and growing up transgender are different things, and that we have different people among us and we should try to get along. That is exactly trying to stop Title VI discrimination. It is not a form of Title VI discrimination. Now, if it is done so badly that it is basically discriminating against people because they are, let's say, white men, then there'd be a Title VI violation. But again, I haven't seen even a claim that that has happened anywhere. I've certainly heard complaints about DEI. I have many complaints about DEI, but I have not heard anybody seriously say this is a violation of Title VI. And you'd think over a decade, you'd see at least one case No, none.
All right, one last question. Yes.
Hi, thank you all so much for being here. My question revolves around a certain provision of Executive Order 14188. And that provision
For those
says.
of us who haven't memorized it.
I was about to read it,
Yeah.
and then there's the question. In addition to identifying relevant authorities to curb or combat anti-Semitism generally required by this section, the Secretaries of State, Education, and Homeland Security, in consultation with each other, shall include in their reports recommendations for familiarizing institutions of higher ed with the grounds for inadmissibility under 8 USC 1182A3, so that such institutions may monitor for and report activities by alien students and staff relevant to those grounds, and for ensuring that such reports about aliens lead, as appropriate and consistent with applicable law, to investigations and, if warranted, actions to remove such aliens. And so the questions about the may monitor and report activities by aliens. So the question is, can the federal government lawfully require or coerce universities to monitor for and report activities, which is a vague term that could include speech. Monitor for and report the speech of F1 visa students.
I think not. If it's a public university, they would be commandeering. The federal government cannot commandeer state governments to enforce federal law. And I don't think, it's not a commandeering principle. That's a 10th Amendment principle when it's a private university. But I don't think the government can compel any private institution to become a police force for it. Now, I do think they can, if it's a student visa and the visa is conditioned on, you take a certain number of credits. I think, you have to establish that you've taken a certain number of credits and you have to get that from the university. But no, the university has no obligation to spy on its students and, attend its protests. And if they, say something that Ilya or Donald Trump doesn't like, report on them so that they can be deported. No, absolutely not. And I would hope that no school would do that, because that would have a tremendous chilling effect on the free speech, right? That is critical to the university. The free speech that Ilya has criticized universities for not recognizing. The way we ensure free speech is not sending a message to the students within our school. Hey, if you say something that we think is problematic, we're going to report you to INS. I don't think so.
It did say activities, so it was 1182, what section was it? What do they have to monitor?
8 USC 1182A3, and that's the
A3.
All the grounds of inadmissibility.
All the grounds of inadmissibility. So it's not
Which includes
necessarily speech, but a lot of it might not be speech for that matter.
Yeah.
But look, schools already have plenty of reporting obligations. The Clery Act about crime statistics and things like that. So it's part and parcel, again, of the funds they receive. So it's not just an ad hoc legislation. You must do our bidding, be our police force. These are, again, strings attached to funding. Now, I haven't looked specifically at whether this can include immigration things, but if it's just information exchange, it might not be an open and shut case like this, especially, again, if it's inadmissible activity and not just speech.
All right, well, we're not going to go on for 9 days. Please join me in thanking our panel. Thank you. Thank you for having me. Thank you. Great questions. Thanks, Leah.
That was so wonderful, Judge. Thank you so much.
My pleasure.
Hero. Yeah, so much.